from Ms. Shinley. I've been an attorney for over 20 years. Much of that time I was a prosecutor. I've seen people do heinous things to each other. I've seen people with their head almost cut off. I've seen murders. I've seen child molestation. I've seen child pornography. I've even prosecuted a child death where the child was tortured. But as I sat here yesterday, I thought to myself, I've never seen human beings do what you two did to another human being. I have a special needs son who's autistic. God placed him with me as a blessing. Many people don't have the blessing to have children. There's probably some here in court today that don't have that blessing. And you threw it away. When Evan ran away from your residence, Miss Shinley, and you were stopped by the police, you never even asked, is Evan okay? That would have been the first thing that I would have asked if one of my children were missing from my residence. And to sit here and listen to testimony where your adopted son, your son, was so hungry that when he was given food at the hospital and crumbs dropped into his napkin, he was so scared that that napkin full of crumbs was going to be taken away. And while I appreciate you not putting your children through this process and making them testify, you should have shown a time to show mercy on them. When I became an attorney, like Ms. Leonard said, we took an oath to uphold the Constitution of the United States and the Constitution of the State of Georgia. Under the 8th Amendment, I'm not allowed to impose a sentence that is cruel and unusual. I'm bound by that oath, and I'm bound by the Constitution. You better be glad that I am. Or otherwise, I would impose a sentence much like the one you imposed on Evan. But that's beyond my authority. I'm taking into account the fact that you did not put your children through this process. I'm also taking into account that you have chosen to accept responsibility in day 2 of this trial, or day 2 of testimony in this trial. Had this case gone further, you would likely be receiving a sentence much higher than what you are about to receive. With that being said, please rise. Ms. Shinley, on count 1, criminal intent to commit a felony, the court finds you guilty. The sentence on that count will be 20 years to serve in prison. On count 2, cruelty to children in the first degree, the court finds you guilty. The sentence on that count is 20 years to serve in prison, consecutive to count 1. On count 3, cruelty to children in the first degree, the court finds you guilty. The sentence on that count will be 20 years probation, consecutive to counts 1 and 2. You'll have the following general conditions of probation: do not violate the criminal laws of any government unit. Avoid injurious or vicious habits. Avoid personal places of disreputable or harmful character. Report to the probation officer as directed and permit such officer to visit your home or elsewhere. Work faithfully at suitable employment insofar as may be possible. Do not change your present place of abode, move outside the jurisdiction of the court, or leave the state for any period of time without prior waiver. You'll submit to a search of your person, residence, papers, vehicle, and or effects at any time, day or night, with or without a search warrant, whenever requested to do so by a probation officer or other law enforcement officer, upon reasonable cause to believe that you are in violation of your probation, otherwise acting in violation of the law. You shall specifically consent to the use of anything seized as evidence in any judicial proceeding. You will have absolutely no contact with the victims and witnesses in this case, including your own children. You will sign a records release which will allow the probation office to have access to all your medical, clinical, treatment, and work records. As part of this probation, you are banished from the Griffin Judicial Circuit, which includes Upson, Pike, Spalding, and Fayette counties. You will provide a DNA sample. This is an offense against a minor. You will have no contact with minors and not be allowed to be around where minors congregate. You will avoid alcohol and drug use, and you shall not possess firearms. On count 4, aggravated battery, the court finds you guilty. The sentence on that count will be 20 years to serve, concurrent to counts 1 and 2. On count 5, cruelty to children in the first degree, the court finds you guilty. The sentence on that count is 20 years to serve, concurrent to counts 1, 2, and 4. On count 6, cruelty to children in the first degree, the court finds you guilty. The sentence on that count is 20 years to serve, concurrent to counts 1, 2, and 5. On count 7, battery, the court finds you guilty. The sentence on that count is 12 months to serve, concurrent to counts 1, 2, 5, and 6. On count 8, false imprisonment, the court finds you guilty. The sentence on that count is 10 years to serve, concurrent to counts 1, 2, 5, 6, and 7. Count 9, false imprisonment, the court finds you guilty. The sentence on that count is 10 years to serve, concurrent to counts 1, 2, 5, 6, 7, and 8. On count 10, aggravated assault, the court finds you guilty. The sentence on that count is 20 years to serve, concurrent to counts 1, 2, 5, 6, 7, 8, and 9. On count 11, aggravated assault, the court finds you guilty. The sentence on that count is 20 years to serve, concurrent to counts 1, 2, 5, 6, 7, 8, 9, and 10. And on count 12, aggravated battery, the court finds you guilty. The sentence on that count is 20 years to serve, concurrent to counts 1, 2, 5, 6, 7, 8, 9, 10, and 11. Now, Ms. Shinley, you have the right to appeal this plea. If you wish to appeal this plea, you must file that paperwork within 30 days of the day's date. Your attorney will go over that with you. Ma'am, you have pled guilty to felony offenses and misdemeanor offenses. With respect to the misdemeanor offense, you have 12 months from today's date to avail yourself of relief under the state's habeas corpus act. With respect to the felony offenses, you have 4 years from today's date to avail yourself of relief under the state's habeas corpus act. Your attorney will go over that with you. Ms. Shinley, do you wish to withdraw this guilty plea and have a jury trial? That'll be the sentence of the court, ma'am. Mr. Shinley. On count 1, criminal attempt to commit a felony, the court finds you guilty. The sentence on that count is 20 years to serve in prison. On count 2, cruelty to children in the first degree, the court finds you guilty. The sentence on that count is 20 years to serve in prison, consecutive to count 1. On count 3, cruelty to children in the first degree, the court finds you guilty. The sentence on that count is 20 years probation, consecutive to counts 1 and 2. You have the following general conditions of probation. Do not violate the criminal laws of any government unit. Avoid injurious or vicious habits. Avoid person or places of disreputable or harmful character. Report to your probation officer as directed or permitted by such officer to visit your home or elsewhere. Work faithfully at suitable employment. Do not change your present place of abode, move outside the jurisdiction of the court, or leave the state for any period of time without permission from your probation officer. Support your legal dependents to the best of your ability. You will have a Fourth Amendment waiver. You shall submit to a search of your person, residence, papers, vehicle, and or effects at any time, day or night, with or without a search warrant, whenever you're requested to do so by a probation officer or other law enforcement officer upon reasonable cause to believe that you're in violation of your probation or otherwise acting in violation of the law. You shall provide a specimen for testing at the request of your probation officer. You're to have no contact whatsoever with any victims or witnesses in this case, including your own children. You will have a records release or sign a records release so that your probation officer can get all medical, clinical, and treatment records. You're banished from the Griffin Judicial Circuit, which includes Upson, Pike, Spalding, and Fayette counties. You will provide a DNA sample. Mr. Shinley, this offense is against a minor. You will not be allowed to be around minors or where minors congregate. You're to avoid alcohol and drug use, and you shall not possess firearms. Mr. Shinley, on count 4, aggravated battery, the court finds you guilty. The sentence on that count is 20 years to serve, concurrent to counts 1 and 2. On count 5, cruelty to children in the first degree, the court finds you guilty. The sentence on that count is 20 years to serve, concurrent to counts 1, 2, and 4. On count 6, cruelty to children in the first degree, the court finds you guilty. The sentence on that count is 20 years to serve, concurrent to counts 1, 2, and 5. On count 7, battery, the court finds you guilty. The sentence on that count is 12 months to serve, concurrent to counts 1, 2, 5, and 6. On count 8, false imprisonment, the court finds you guilty. The sentence on that count is 10 years to serve, concurrent to counts 1, 2, 5, 6, and 7. On count 9, false imprisonment, the court finds you guilty. The sentence on that count is 10 years to serve, concurrent to counts 1, 2, 5, 6, 7, and 8. Mr. Shinley, you have the right to appeal this plea. If you wish to appeal this plea, you must file that paperwork within 30 days of the day's date, and your attorney will go over that with you. You're pleading guilty to a misdemeanor offense and felony offenses. With respect to the misdemeanor offense, you'll have 12 months from the day's date to avail yourself of relief under the state's habeas corpus act. With respect to the felony offenses, you'll have 4 years from the day's date to avail yourself of relief under the state's habeas corpus act. Your attorneys will go over that with you. Mr. Shinley, do you wish to withdraw this guilty plea and have a jury trial? That way the sentence of the court, you can take him out. Anything else we need to take up from the state before I bring this jury in and release it? Anything from the defense? No. Ready, Judge?
All rise, yes.
All rise.
All right, everyone have a seat. We're back on the record for State of Florida versus Tracy Nix, CF 22-289. Members of the jury, did y'all reach a verdict? Who's my, if my foreperson would raise their hand and hand the verdict to the bailiff. All right, defense, please rise. Mrs. Nix, please rise. All right, we're going to go ahead and publish the verdict.
In the Circuit Court of the 10th Judicial Circuit of Florida in and for Hardy County, State of Florida versus Tracy Howard Nix, case number CF 22-000-A000-XXW. Verdict form. We, the jury, find as follows as to count 1 of the charge. The defendant, Tracy Howard Nix, is not guilty. We, the jury, find as follows as to count 2 of the charge. The defendant, Tracy Howard Nix, is guilty of leaving a child in a motor vehicle in excess of 15 minutes, causing great bodily harm.
Don't
So-
read, don't read anymore.
Yes, sir.
All right, thank you. Mr. Fletcher, you wish the jury to be polled?
No, Your Honor.
State, you wish the jury to be polled?
No, Your Honor.
I'm going to release the jury.
No objection.
All right, all rise. Members of the jury, I want to give you your final instruction. Hold on one second. Ladies and gentlemen, I wish to thank you for your time and consideration of this case. I also wish to advise you of some very special privileges enjoyed by jurors such as yourself. No juror can ever be required to talk about the discussions that occurred in the jury room except by court order. For many centuries, our society has relied upon jurors for consideration of difficult cases. We have recognized for hundreds of years that a jury's deliberations, discussions, and votes should remain their private affair as long as they wish it. Therefore, the law gives you a unique privilege not to speak about the jury's work. Although you are at liberty to speak with anyone about your deliberations, you are also at liberty to refuse to speak to anyone. A request to discuss either your verdict or your deliberations may come from those who are simply curious, from those who might seek to find fault with you, from the media, from the attorneys, and elsewhere. It will be up to you to decide whether to preserve your privacy as a juror. I want to thank you on behalf of the citizens of Hardee County and Polk County for spending your time with us. Thank you very much for your time and consideration. You may be excused.
Even note.
All right, all, once they leave, have a seat, and I'll have the defendant proceed to the podium with their attorney. Okay.
Here.
Right there. Okay. Ms. Hicks, stand next to your attorney, Mr. Fletcher. Everyone can have a seat. Mr. Fletcher, Tracy Nix, having been found guilty by a jury as to the charge of leaving the child unattended in the vehicle for more than 15 minutes, contained in case number CF 22-289, I now find you to be guilty of the offense. State, what's your position on remand or bond?
Your Honor, she's been convicted at this point. I would ask that she be taken into custody.
Defense, position on remand or bond?
Your Honor, I request that she be allowed to be out on bond until we have a sentencing hearing. Will be requesting a less than guideline sentence. I will request, based on my experts, that you partially heard that her sentence be below guidelines. I have also had my office contact the bail bondsman. He is willing to remain on the bond. I can tell you that as an officer of the court. There's plenty of time to incarcerate her. I do need her also to be able to prepare for sentencing.
All right, state anything further?
And further, Judge, she's been on pretrial release for over 2 years. There hadn't been a seconds problem with her. She's been to every court appearance that we've had, and I see no reason to remand her at this time.
State anything further?
No, the state stands by its previous position.
All right, a sentencing date of April 3rd at 8:30 a.m. Does that work with state?
We will make it work.
Defense, does that work with defense?
Same as the state will make it work.
All right. At this point in time, based upon the jury verdict of guilty, I'm remanding you into custody, Ms. Nix. You are to be with the sheriff pending the pre-sentence investigation report by the Florida Parole and Probation Commission. Your bond is hereby revoked. You will be held at no bond. I hereby order the Florida Parole and Probation Commission to prepare a pre-sentence investigation report upon the defendant and furnish same to the court as soon as practicable. You will appear April 3rd, 2025 in the Hardee County Courthouse at 8:30 a.m. I've set aside a full day for the sentencing. I'd ask the defense and the state to be prepared to present their arguments and testimony that they feel is appropriate to have this court sentence Ms. Nix in accordance with this verdict. Anything further, state?
Nothing further, Your Honor.
Anything further, defense?
No, Your Honor.
All right, all rise. I'm going to get off the bench. Come on outside.
No, he does not want to be outside. I think just let your man do it.
All right, ladies and gentlemen, court is adjourned. Everybody can exit the courtroom now, please.
Thank you. You too. You're going to finish your call? This judge aware?
Yeah.
All right, thank you. You may be seated. Kathleen, you're going to have to get up. All right, so ladies and gentlemen of the jury, I've been told you have a verdict, and so I'll ask the foreperson to please provide the verdict to my bailiff. Thank you. All right, ladies and gentlemen of the jury, at this time, we thank you for your service. Again, I don't think any of us could go too far beyond saying that having you for 2 weeks, we know has been a cause for you to disrupt your lives, and so we thank you for your service. At this time, I'll read the verdicts on all charges, and then with respect to that, I will poll each of you just to confirm that it is your decision of this verdict. So with respect to the 9 counts and the furthermore, this jury says that they duly find and impaneled as sworn jurors in this case do find the defendant, Bianca Ellis, guilty of all charges. Those guilty charges also carry with it the furthermore that she did commit the other charge as requested with a finding of all 12 of you. So with that being said, juror number 1, is this your decision?
Yes.
Juror number 2?
Yes.
Juror number 3?
Yes.
Juror number 4? Juror number 5?
Yes.
Juror number 6? Juror number 7? Juror number 8? Juror number 9? Juror number 10? Juror number 11? And juror number 12. All right. Thank you. Again, I thank you for your service on behalf of Cuyahoga County and the 34 judges here. And we, at this time, will rise for the jury and we'll have a moment to speak to you afterwards. I'll have counsel to sidebar to review the verdict.
Everyone be seated.
Thank you. You can be seated.
Thank you.
All right, so at this time, having an opportunity to review the verdict forms, the court is going to set a sentencing date. I had asked the lawyers, I'm going to set it for October 27th at, again, 8:30 in the morning. I think we've been pretty consistent with being available at that time. I know that some of you have a trial calendar that might have some conflict. I'll ask that if you can discuss with the courts that you're currently going to be engaged with or potentially going to be engaged with. If I need to call any of those judges, I'd be happy to. But if we could do it, allow everybody that opportunity to be present as well. Anything further from the state of Ohio?
No, Your Honor. Thank you.
On behalf of Ms. Ellis?
No, Your Honor.
All right. Again, I thank all of you for professionalism as well throughout this trial. And so we'll recess at this time, and we'll be back on October 27th. All right. We'll adjourn.
Thank you.
Good afternoon, ladies and gentlemen of the jury. I want to thank each and every one of you for your attention and your concern throughout this process. We've been together for many days now, and I know you've been paying good attention to every witness and all the testimony that you've heard. I think we can all agree that it's tragic circumstances that have brought us together. But as Ms. Feralia told you at the outset of her opening statement, it is a privilege to present this case to you on behalf of the state of Ohio. And before you get to deliberate on this matter, I will provide my opening closing argument. Then you'll hear from Mr. Mack and Mr. Johnson, and then you'll hear once again from Ms. Feralia, because the state of Ohio bears the burden, and you'll hear from the state last before you deliberate. Ladies and gentlemen, we are all together today because of the choices Bianca Ellis made on June 3rd of 2024. That day was like any other day in the life of Margot Wood. And I think we can all relate to what she did that day. Take your kid to the grocery store. It's something that is fun. It's a little get out of the house, buy candy, flowers with your child. And yet, that ordinary act turned into an unfathomable nightmare because of what this defendant chose to do on that day. So what I'm going to do is I'm going to walk us through the indictment, the charges that we have charged Bianca Ellis with, and then we're going to shift our conversation to the affirmative defense that she has raised. All right? So I want to start with count 1, which is aggravated murder. That Bianca did purposely and with prior calculation and design cause the death of Julian Wood. And under Ohio law, the key terms here are prior calculation and design. All right? Those are the words you want to pay attention to when you're deliberating on count 1. What does prior calculation and design mean? Well, you'll have those instructions with you when you deliberate. And in part it says, it's the process of reasoning that must have included a mental plan involving studied consideration of the method and the means, or the instrument with which to cause the death of another. The amount of time that the defendant spends in planning isn't really as critical, but she needs sufficient time and opportunity for the planning of the homicide. So did Bianca Ellis give thought or preparation to choosing the murder weapon in this case? Yeah, she absolutely did. And we can all see it in State's Exhibit 192. And you'll have this, 193. 182, Your Honor, I apologize. Sure. Ladies and gentlemen, you will have these videos back with you when you deliberate. I'm going to let this play for just a second, and then we're going to be quiet. I'm going to be quiet for about 50 seconds while we watch Bianca Ellis choose her weapon. 50 seconds. We watched that defendant go directly to the houseware aisles in Volunteers of America, go through that bin, look at the knives, inspect them, handle them, look up top of the knife block up there. She spends almost a minute looking through these knives. She doesn't pick the first one she sees. She finds the two favorites of hers, and then she walks out of the store. She made a decision. That was careful. We spent a lot of time on cross-examination with Dr. Knopfsinger today about how Bianca Ellis didn't just stab anyone in the Volunteers of America store. No, and that supports our argument. This was calculated. She walked out of that store and went to the store next door. Encounters more people on her path. And then when she gets to Giant Eagle, that's when she chooses her victim. But she knew when she chose those knives what she was going to do. She was going to harm someone. She was going to take somebody's life. Now, murder is count 2 and 3, and they're charged under different sections. So count 2 is that Bianca Ellis did purposely cause the death of Julian Wood. And count 3 is that she caused his death as a proximate result of an underlying felony. And what we mean by that is that he died because she committed or attempted to commit felonious assault and or endangering children. And with these charges, there are degrees of culpability and mental states. Okay, so when we're talking about purposely, and again, you'll have all this in your instructions, but these are the definitions of purposely and knowingly. And we're talking about this defendant knowing that her actions would bring about a certain result. Okay, so we know that when she selects that butcher knife and she ultimately stabs 2 people with it, that she's going to bring about a result, right? She's going to hurt them, she's going to kill one of them. And you think about it, with a butcher knife, if you stab somebody, that's going to be the result. You harm or kill. Okay, so when you deliberate these counts, ladies and gentlemen, you can consult your instructions. I'm not going to go through these ad nauseum, okay? I know that you are a smart, attentive jury, but I do want you to pay close attention to count 1 and talk a lot about that prior calculation and design and the plan that Bianca Ellis had that day. And of course, she had no relationship to these people, and that's okay for proving prior calculation and design. You want to focus on the time and the consideration that she spent choosing her weapon and the steps she took after that. Now, we're going to go through the timeline. We have the benefit of really having all of these actions captured on video. So we know that in a couple days prior to June 3rd, Bianca Ellis had a run-in with the North Olmsted Police Department. And that's important because it's part of the anger that fuels her on June 3rd. You heard testimony about how she was in their jail for a night and that she was purported to have all sorts of property and money and gift cards and other items. So when she's walking around on June 3rd, we know that that's on her mind. She says as much herself. But let's walk through this timeline that we have. right? And again, you're going to have these videos, you'll have the compilation video that we went through together. But what I put together today is a kind of a streamlined timeline, all right? So we can see kind of minute by minute where she is. So at 2:36, you see her in that yellow circle. She's in her wheelchair. She's on the North Olmsted Police Department property. A couple minutes later, here she comes into the lobby, and you meet Danielle Shook, one of the first witnesses you heard in this trial. And if you remember how their encounter went, Bianca Ellis wasn't so happy when she left the lobby. Remember, she turned the lights off as she departed the lobby. And then she kind of skips down the stairs. She ditches her wheelchair and her suitcase. And you can look at the video. Again, of course, you heard testimony that she walked with purpose and that she was angry. You can watch that video again that we watched here this afternoon. The careful selection of the weapons, minute by minute here. 14:55, so 2:55, less than 20 minutes after she went to the police station, she's got her weapon. 14:56, she's going to enter the things outlet. She walks in, looks around. Pay attention. She's got 2 knives still behind her back, and she's looking around. Ladies and gentlemen, she's looking for a victim. These people, they're adults. There's men in the store. Those aren't suitable victims for Bianca Ellis. She's got to find the most helpless victim she can to carry out her crime. She exits. What does she do then? Well, she's got 2 knives. She can't use 2 knives. So she's got to ditch one. She's got to keep the best one. What does she do? She taps her knives against the brick column, ditches the flimsy one, keeps the superior knife to carry out her act. Look at her walk. She's not going into that store for anything but to wreak havoc on somebody that she hasn't chosen yet. And unfortunately, or fortunately, how you want to frame it, again, it's all on video, what she does that day. 2:57, there she is, knife in hand. Again, this is 22 minutes have passed since she went to North Olmsted for her money. And here it is. Ladies and gentlemen, this is the decision she makes after she's selected her weapon. These are the people she wants to harm. It's been decided. This is a volitional choice, ladies and gentlemen. This woman is not experiencing, and we'll get there, but this is a woman who has made decision after decision and planned this out. And finally, at 3 o'clock, we know what happens. Now, part of my job here is to make sure that you understand the elements. I'm not going to dwell on this at all, but we know that a child died. To prove that there was a death in this case, we had to show some autopsy photos. All right, I'm not even going to enlarge them on the screen here. You can see these 2 photographs. We know that we have a deceased victim. We also know that Margot Wood was stabbed and that she was injured, okay, for the attempted murder charges and the felonious assault. She has scarring on her body, and she will always have that scarring. So the state has met its burden as to those counts as well. this case is unique, of course, as we all know, that the burden shifts, right? The state has proved beyond a reasonable doubt all these elements of all the charges against this defendant. Now, there's another step, and you all know it, and you don't have to overthink it. I know it is complex, but at the same time, you want to take it step by step and not overthink what we have to do. So what does it mean that she raised this defense? Well, you know that she has to prove something to you. Has she done that? And how can we tell? Again, I'm not going to read all this stuff. I usually don't put much writing on these slides, but because there is so much to get through, I want you to be prepared for what you'll have to read and talk about in your deliberations. The testimony from Dr. Knopfsinger is pretty fresh in all our minds because he finished his testimony today. The fact that this defendant has schizophrenia does not excuse her for her conduct. So now we are talking about kind of the battle of the experts. Let's talk about Sarah West. All right, you heard from her last week. Her opinions are based almost solely off of this defendant's self-reports. I don't know about you, but I got the sense from her testimony that she either hadn't watched the videos or really did not remember them and did not factor into her analysis of this defendant. You'll have her report to go through. When she was asked about basic things about these videos, she did not seem familiar with them whatsoever. And you've heard from Dr. Knopfsinger how crucial these videos are. This timeline, the methods that this defendant goes through to make her decisions, Dr. West seems to not put much weight in that at all. So that's what I mean by she does not use corroborative evidence from June 3rd. But she agrees with us that June 3rd is the day we're going to focus on. We're not really talking about too much that happened before. We're going to talk a little bit about afterwards, but really June 3rd is what we are really focusing on. Something that struck me about her testimony was that Dr. West said, I see a lot of psychosis here. And I didn't really know what she meant by that because, again, she didn't use corroborative evidence. Not one witness in this trial testified that Bianca Ellis was talking to herself or muttering things, talking to anybody. So Dr. West's suggestion that she was hearing voices didn't make a whole lot of sense to me. And we talked a lot about anger and rage, and that is really the crux of Dr. Knopfsinger's report. And we know that Bianca Ellis was not medicated on June 3rd, but we believe she was very angry, and that motivated her to commit these crimes. But Sarah West doesn't talk about anger. She kind of agrees with us eventually that anger could cause someone to commit a crime. But again, she is not focusing on anything but old medical records and the defendant's responses. Do you remember Dr. West talking about disorganization? That was a big theme of her report and her presentation. And she didn't really define it. And she also said things like, I believe, and maybe so, and probably. Ladies and gentlemen, the preponderance of the evidence is a different burden than the state has to prove when we are proving the elements against this defendant. Think of the tipping of the scales. Okay? It doesn't have to be much of a tip. If you don't believe Sarah West, the defendant has not met her burden in this case. And I submit to you that she has not met that burden. Her theme doesn't make a whole lot of sense. She kept saying that this defendant was disorganized. And I did not find that to be helpful because she didn't really explain it, but Dr. Knopfsinger does. What does he say in his 36-page report where he overturns every video, every record, every interview, and he analyzes it through his expert lens? And again, you can see his report, you can read every word. he talks about what disorganization means. It is word salad. It is gibberish. It's nonsensical. His examples that illustrated this were someone that is loitering or trespassing and doesn't understand what they're really doing. They're kind of aimless. Bianca Ellis isn't aimless. She's angry. She's not disorganized. She's committing a specific willful act. She is not a disorganized person. And Knopfsinger really delves into that for us. So here we are. There's two prongs, as you know. I know you paid good attention in this case. And it's the second prong that we are really focusing on. There is no question this defendant is schizophrenic. That's prong one. Bianca Ellis suffers from a severe mental disease, a schizophrenia. However, the fact that she has that diagnosis does not mean that she didn't know what she did was wrong on June 3rd. Pay attention to her interview with Dr. Knopfsinger. Okay? She's not being paranoid. I thought some of the best testimony that made sense to me was about, oh, she's not talking about, there's aliens or there's ghosts or whatever there is that I'm protecting these people from. There's no delusion. There's no grandiose explanation for what she did. She doesn't think that these people are harming her. Those were examples Knopfsinger used to explain why someone might act the way she did if they truly were insane at the time of that act. We have none of that here. None of that. She is fueled by anger. She is dehydrated. These are her words. You'll watch the video. She's dehydrated. She's hungry. She hasn't slept. It became a perfect storm. Keep in mind, Dr. Knopfsinger has testified for the defense and the state. He's 30 plus years of being a psychiatrist. He has seen a lot of different things come across his desk. He has no interest in the outcome of this case beyond the work that he did, the report he made. He's telling us what is based on his experience, his training, his knowledge. This is not an NGRI defendant, and here's why. Today, he told us that in order to be successful on this affirmative defense, she's got to prove that what she thought, what she did, was right. And she has not explained that in any way. There is no rational motive. I'm sorry, the rational motive that she provides is what we need to focus on. Hungry, dehydrated, missing money, it all comes together. And when she's angry and she sees those people, the relationship, the close relationship in time, that's what we have. That's why we're here. So, ladies and gentlemen, you'll have all the evidence. You can go through all of it. And I know there's a lot. There's body cam and there's interviews. Watch her interview the next day. I want you to do that because she's still very angry the next morning. And I remember we played the interview in court, how loud it got towards the end. You could hardly hear her in the beginning. And then later on, she's shouting, stupid people, liars, thieves. And again, the way she acts directly after this. Dr. Knopfsinger pointed it out, and I think the other witnesses explained it as well. She is not saying, no, don't arrest me. I didn't do anything. She doesn't run away. But she does walk away calmly. She doesn't stay on scene at the car. She succumbs to the officer commands. She never protests her arrest. And Knopfsinger tells us that these are behavioral factors that indicate that she knew she did something wrong. The actions of stabbing. What a personal, gruesome thing to do. And I think on cross-examination, Mr. Johnson talked about, well, wouldn't 30 stab wounds be more indicative of rage? No. Ladies and gentlemen, stabbing anybody with anything is an act that would be fueled by anger. To have a 10-inch knife with a 7-inch blade and to select the most helpless victim possible and then stab that victim twice, that is rage. That's what we have in this case. All right, so here we are at the very end, kind of to recap our timeline. She's upset. She goes directly to the knife houseware aisle in Volunteers of America, and she carries out her crime. Ladies and gentlemen, I urge you to go through all of the evidence together. I know that within your collective memories, 12 of you, some of you may have taken lots of notes, some may have not taken many notes at all. And that's all right. Listen to one another. Talk to one another. Go through every video, the reports by the doctors, and discuss. Think but don't overthink. Bianca Ellis is responsible for the death of Julian Wood. And Mr. Mack told you that, if you remember, in his opening statement a week ago. But she did it with prior calculation and design. She knew what she was doing that June afternoon. Hold her accountable for what she did to that child and his mother. She knew what she did was wrong. Find her guilty. Thank you.
Judge, for the record, we point the court to Vice Code 292912, the seriousness and recidivism factors. Turning to large letter A, the two that are most applicable from the record that we've seen here is number one, the victim suffered serious physical harm. Lieutenant Reese's testimony plus the state's exhibit. The baby was mauled to death by this pit bull mix. So that's present. That's a factor indicating a more serious effect. Number two, the offender's relationship with the victims facilitated the offense. That appears to be there. The mother obviously has an obligation to protect the child. We don't see any of the other factors, 3 through 6, being applicable. When we turn to 292912B, factors indicating the offense is less serious, Mr. Johnson can argue that the state doesn't see that any of those apply. Turning to 292912C, which are factors indicating a higher likelihood of recidivism, we would point the court to factors 3 and 4. Number 3, that's a history of substance abuse, tends to lead to recidivism. And 4, a lack of remorse, as described both by Lieutenant Reese in his testimony and by the aunt of the baby. Looking at 292912D, the state wants to be as fair as possible. Number 3 probably does apply for a lower likelihood of recidivism. The offense was committed under circumstances unlikely to recur. The state would like to think that this defendant will never own a pit bull and have a pit bull around a dog again, around a child again. So I'll let Your Honor balance that. But by way of full fairness, we want to direct your attention to D3, which may be a factor that shows a lower likelihood of recidivism. With respect to 292912E, which are some people in sentencing law call that the catch-all provision, any other relevant factors, The state has presented those relevant factors to you in the exhibits that we've handed up and put on the screen that shows the seriousness of this offense. Judge, you should know that defendant's counsel advocated very aggressively and professionally on behalf of his client. Mr. Johnson was in touch with the state, pushing very hard for his client's interests. And only through his diligent approach did we consider some form of a resolution to this matter short of a jury trial. Because as Your Honor knows, a jury trial is a never guaranteed result. We would have to get a unanimous verdict on every element of every count from the jurors. And of course, there'd be many years of appeals afterward. And so with that in mind, defense counsel and the state came up with an agreed recommendation, largely based, Judge, you were here for the change of plea, you conducted the change of plea, because we have two other pending matters against the co-defendant, Mr. Bates, one of which is testimony in the case about Baby Royal, and there were only 2 adults in the house that day who could be suitable to testify, and Ms. Smith could have availed herself of her Fifth Amendment right and not testified and not cooperated with the state. And then Mr. Bates, as the court knows, faces a strangulation charge related to a domestic violence incident where Ms. Smith was the victim, and there would have been no way the state could have required her to participate in that prosecution. So largely because we needed the cooperation of Ms. Smith in these 2 other matters, the state was willing to accede to the diligent advocacy by defense counsel and recommend a joint recommendation of 90 days in jail. After we were able to make that agreement that the defendant here in this case would plead guilty, Mr. Bates then changed his pleas on the other charges, and we'll proceed to sentencing at another time. We'll talk about that then. Judge, whatever you do, the state stands on its recommendation, but whenever this defendant is out again, we would encourage the court to add additional factors to whatever release supervision she has, including no dogs, including no felons, including something about substance abuse, and something about maybe regular visits by children's services, so that if she does have her daughter with her, that there's somebody with an independent perspective who can ensure that that daughter is in a safe environment. So with that, Judge, the state is done with its argument.
Thank you, Mr. Weaver. Mr. Johnson, you have anything you want me to know about your client?
Yes, Your Honor. So I guess just at the outset, there were questions and testimony provided about fetal drug exposure. We don't see how that has any relevance here whatsoever. We're here involving a dog, unfortunately, killing a child. I'm not sure how any evidence or testimony about what may have happened during the pregnancy has any relevance to what we're going on here. So I'd ask the court to disregard that. As far as the actual case itself here, Mr. Weaver, I think correctly summarized for the court that my client, she is a victim in a felony domestic violence case. I know myself, we have very experienced counsel in the room, and yourself, Judge, when you were when you were in practice as defense counsel, we all know domestic violence situations, that is not the first and only time that it's ever happened. It's charged as a felony, which by definition means it was not the first time. And my client was willing to cooperate through that process. We met with the prosecutor's office. So it's not just cooperation in this case, but also in the other matter involving Mr. Bates. I think that was probably rather important for the state of Ohio. It forms the foundation, I believe, of the recommendation that we're joining with the court to propose in the 90 days with community control. And I'm also going to surmise that the state probably provided that evidence to defense counsel for those 2 matters, and was probably rather persuasive in Mr. Bates eventually deciding to enter a plea. So there actually was real value in doing those sessions with the state and cooperating with the state. Just candidly, it probably assisted in leading to convictions in both those matters. Now, along those same lines, Your Honor, about domestic violence and never being the first time, people that are the victim of domestic violence, they continue to experience that on an ongoing basis, even when someone's incarcerated, that kind of pressure from someone can absolutely lead to someone continuing to communicate, continuing to be fearful of that person. So I guess, Your Honor, what I'm suggesting here is that if this matter had went to trial, those instances of domestic violence would more than likely have become relevant at trial as a necessary background. I believe Mr. Weaver and Mr. Rogan would agree with me that if we went to trial, there were evidentiary problems for both sides. There were going to be evidentiary problems proving one of the more severe offenses that had been dismissed from the state's perspective. In all candor, from the defense's perspective, there was evidence showing that there was, at least a negligence, even not maybe a recklessness, that led to the death of Royal. So I think we all appreciated that, and trying to come up with a resolution that seemed fair given what we had here, and also recognition that while Ms. Smith certainly played a role here, I think we can all acknowledge that Mr. Bates was sort of the person leading the charge. He had owned this animal beforehand. His own family members had told him that this animal is a problem, that the animal is aggressive, and it wasn't necessarily Ms. Smith's. She had no legal authority to tell him to get rid of the animal. So I think we all have a recognition that he was really the primary problem going on in that house. Now, also as part of our agreement, Ms. Smith cooperated with a Children's Services investigation. Children's Services came out to the house because my client still has another child in the house that she cares for. I think the state, from their perspective, wanted to make sure there wasn't an ongoing issue going on in the house, and so we agreed to that. We were very open about it. Children's Services came to the house and found no issues. That is also, I think, one of the reasons why the state was willing to move forward with this recommendation to the court. Now, ultimately, Your Honor, I think this goes towards the primary purposes of sentencing, and I would agree with the state that the primary purposes are to punish the offender and protect the public from future crime. In looking at the PSI, my client has some assorted traffic convictions, but her only criminal convictions are disorderly conduct minor misdemeanors. So she's never even had a criminal conviction for which she would be subject to any form of incarceration. The 90 days that we're proposing to the court, not only is it going to be life-altering for her because she's never really experienced any form of lengthy incarceration, but I'd also suggest to the court, I cannot fathom for a parent a more severe punishment than recognizing that at least in part you played a role in the death of your own child. That's referenced in the PSI. To paraphrase it, she says explicitly in there that I'm pleading guilty to child endangerment because I played a role in the death of Royal. She's going to be in a prison of her own making for the rest of her life, having to live with and acknowledge the idea, and have her family members come in here and acknowledge the idea that she played a part in here. The court can fashion any kind of sentence that it wants. It can disregard the joint recommendation of the parties, but I guess I'm going to submit to the court that no matter what you do, there's no more severe punishment than having to live the rest of your days knowing you played a part in the death of your child. The 90 days, to be candid, seems more like it's a recommendation, but it's a visceral need to attach some level of punishment here. But I'm going to suggest to the court that it doesn't matter if you do 90 days, if you do 3 years or something in between, there is nothing that is going to be more of a punishment to Ms. Smith, than realizing that you played a part in your child passing away, and then having to explain that to your other child. It's not something I've ever experienced, not something I ever want to experience, but I can only imagine the pain involved in that and living with that for the rest of your days. So, Your Honor, I hope you take all of this information into account and fashion an appropriate sentence. And the parties themselves have, Mr. Weaver and I have spoken countless times about this, including when I think both of us were on vacation trying to figure things out. But we are familiar with the evidence. We're trying to come up with something that is reasonable here. And 90 days plus community control with the court not only supervise Ms. Smith, I think part of that would be not owning any kind of dogs. I think satisfies the need for punishment and also protecting the community. Thank you, Your Honor.
Thank you, Mr. Johnson. Ms. Smith? Yeah.
Just real quick, Judge, the state agrees. The way that Mr. Johnson described the interactions and how the plea team would be, everything that Mr. Johnson said is correct.
Court has considered 2919B2. I've also considered the entire record, including the pre-sentence investigation report, victims' impact statements, the statement here today by Ms. Smith, Rule 11F statements regarding plea negotiations, the recommendations made by counsel, the plea agreement, Statements of counsel here today and the statement of Ms. Smith also consider the purpose and principles of sentencing as outlined in 292911A, and that states as in determining the appropriate sentence, I'm guided by the overriding purpose of felony sentencing, which are to protect the public from future crime by the offender and others, and to punish the offender using the minimum sanctions that the court determines accomplish those purposes without imposing an unnecessary burden on state or local or government resources. I'm required to consider the need for incapacitating the defendant, deterring the defendant and others from future crime, rehabilitating the defendant, and making restitution to the victim of the offense, the public, or both. I've also considered the seriousness and recidivism factors, all as contained in 292912. I've considered the testimony here today from the officer, the PowerPoint presentation, the other information is provided by the state and the defense. This case is unfortunate in that there's loss of life, and that you, Ms. Smith, is or are a victim to this because you were the mother of the child. When the court looks at the sentencing criteria, there's only one conclusion that I can come to, and that's that you're not amenable to community control sanctions. This court is not going to follow the joint sentencing recommendation. While your lawyer did great work to get you that sentencing recommendation, I also would let you know I wasn't very happy about the plea. However, the things that were stated in this court today regarding complexities with criminal cases involving evidentiary issues, co-defendant charges, cooperation, and ultimately the state's prerogative in evaluating and assessing cases. Your defense lawyer's knowledge of the case, my knowledge of the case, comes largely at this point. While I was reluctant to accept a plea, I did accept that plea, which cuts you in a significant advantage and risk. So you need to remember that the court considers as part of this sentence the cases that were dismissed and the containment of damages that allowed. However, the court specifically finds that you have no remorse for this, or you at least shown no remorse. You also violated your bond while you were on bond. Then you turn around and back out. You were continuing your relationship with Mr. Bates through surreptitious means, which demonstrate that you're not following court orders. And you can look at me like you don't know what I'm talking about, but you must not have heard the officer testify about you using phones and fake names to continue your communication. While you might have cut a deal at the last moment to cooperate in the state's case, that was done, in my opinion, to save yourself and not for any other reason. The case did pen for quite some time. This case is quite old from the date of offense. I also find that you have a drug issue and or alcohol issue that you fail to acknowledge or take any ounce of responsibility for. It's also a case, while I agree with everybody's statements that there was no intention for this child to be harmed, let alone killed, it's also, putting it mildly, to say that you and Mr. Bates were extremely reckless in your conduct in owning this particular dog, having other dogs in the house. I watched a video where your dog attacks a child in the child's own yard because you turned the dog loose repeatedly with no concern of what the dog, havoc that dog wreaks on the public. And probably by the grace of God that dog did not attack that child worse than it did. The dog obviously has extreme violent tendencies where it mauled this child unprovoked for no reason. You've told numerous stories as to how it happened, but the main issue is you failed to remedy the situation by containing and controlling your dog. I've seen it over and over. You have this desire to have these dogs that have tendencies to be aggressive, and then once they demonstrate the aggressiveness, there's nothing done to contain the dog. You're clearly incapable of managing that particular dog. Very few people probably could, but yet you're letting it run through the neighborhood after you're told it almost attacked a child. Now that would be concerning to me. That would have been concerning enough for me to get rid of the dog when I can't control it and it goes into somebody else's yard. Fail to see the purpose of having a vicious dog, one that attacks for no purpose other than you think it's, I guess, cool to have that type of dog. I'm not sure what the point of having a dog that you never know is going to bite somebody. And that responsibility falls 100% on you and Mr. Bates electing to gamble. And when you gamble with high-risk situations that you can't control, nor had much interest in controlling, the dog was aggressive to more than one person. Your own family members advised you to get rid of the dog, but again, none of that was listened to. The consequence of this case is grave. A child lost its life, and we can't look at the fact that, or ignore the fact that the ultimate consequence, because of your reckless conduct, resulted in an unnecessary death. I think it's very true to say that this is 100% avoidable, and there's no way that this court is going to ignore the severity of this case and your failure to understand why we're here. When your own family, and I'm not just talking about your sister, everybody else here recognizes your failure to recognize this, your conduct and your failure to understand the importance of pet ownership, and more importantly, having a child and your duty to protect the child. And this court can come to no conclusion other than that a prison sentence is warranted in this case. If I could give you more than 3 years, you'd get more than 3 years at this point, especially after the information that was presented here today. Court will impose a prison sentence of 36 months. You are now what's subject to being sent to prison. Once you complete your prison sentence, you're subject to what is known as post-release controls in this case. Post-release controls is discretionary or optional. Is that correct, Mr. Weaver? It's discretion on this particular charge still, right?
Yes, Judge.
You agree with that, Mr.?
I do.
You'll be discretionary or optional post-release controls for a period of up to 2 years on your release. That means you'll be subject to monitoring and supervision by the adult parole authority. You'll be given probationary type terms on that supervision. If you violate the terms of your post-release controls, you can be sentenced back to prison in increments of time that cannot exceed 1/2 of your original prison sentence. If while you're on post-release controls you were convicted of a new felony offense, you can receive an additional year in prison, or the number of months remaining on your post-release controls run consecutive to any time you get on the new felony. While you're in prison, you're not to ingest or be injected with any drugs of abuse. You must submit to random drug testing. While you're in prison, I don't make any determination whether you're eligible, but you may be eligible for up to 5 days of credit toward your sentence for each month that you productively participate in educational programming, vocational training, substance abuse treatment, or other productive programming. You will receive a fine of $1,000. Court costs will be assessed in this case, and there'll be a partial assessment of attorney fees of $500. I believe you have 13 days of jail credit. Does anybody dispute that? All right, you will be awarded 13 days of credit up to the date of sentencing, which is today. Ma'am, you've now been sentenced on this case. You will have a right to appeal your sentence within 30 days after the filing of the court's sentencing entry. If you cannot afford the cost of appeal, your appeal will be filed without payment. If you cannot afford a transcript, one will be provided you at no cost. If you cannot obtain counsel for appeal, counsel will be provided to you without cost. Am I missing anything?
Nothing from the state judge. I think you covered it.
All right. You will be remanded into custody. Anything further from the defense? All right. This matter is adjourned.
Thank you, Judge. Thank you, Your Honor.
there anything else on it? No? That's okay. Let me wrap up, y'all. Really? What? You want me with you? Yeah. Okay.
Murder. To judgment of this court, you are guilty. In count 2, a jury of your peers having found you guilty of first-degree murder and the perpetration of a felony, it's a judgment of this court, you are guilty. In count 3, a jury of your peers having found you guilty of first-degree murder and the perpetration of a felony, it's a judgment of this court, you are guilty. In count 4, a judgment of your peers having found you guilty of aggravated child abuse, it's a judgment of the court, you are guilty. In count 5, a jury of your peers having found you guilty of aggravated child neglect, it's a judgment of the court, you are guilty. In count 6, a jury of your peers having found you guilty of tampering with evidence, it's a judgment of the court, you are guilty. In count 7, a jury of your peers having found you guilty of false report, it's a judgment of the court, you are guilty. In count 8, a jury of your peers having found you guilty of false report, it's a judgment of the court, you are guilty. In count 9, a jury of your peers having found you guilty of false report, it's a judgment of the court, you are guilty. In count 10, a jury of your peers having found you guilty of false report, it's a judgment of the court, you are guilty. In count 11, a jury of your peers having found you guilty of false report, it's a judgment of the court, you are guilty. In count 12, a jury of your peers having found you guilty of false report, it's a judgment of the court, you are guilty. Count 13, a jury of your peers having found you guilty of false report, it's a judgment of the court, you are guilty. Count 14, a jury of your peers having found you guilty of false report, is a judgment of the court, you are guilty. In count 15, a jury of your peers having found you guilty of false report, is a judgment of the court, you are guilty. In count 16, a jury of your peers having found you guilty of false report, it's a judgment of the court, you are guilty. In count 17, a jury of your peers having found you guilty of false report, it's a judgment of the court, you are guilty. In count 19, a jury of your peers having found you guilty of abuse of a corpse, it's a judgment of the court, you are guilty. And in count 20, a jury of your peers having found you guilty of failure to report a death under suspicious, unusual, or unnatural circumstances, it's a judgment of the court, you are guilty. In counts 4 through 20, the jury did not assess a fine, so there'll be no fine assessed in those counts. Now we'll be in recess about 15 minutes.
Thank you. Court stands in recess.
It is my understanding that a decision has been reached. Yes?
That's correct.
Yes. And is it unanimous?
Yes.
And all signatures are affixed to the document?
Yes.
If you'll please provide that document to Deputy Moore. Thank you. I told you when this started that I needed you to do this job. Thank you. You may be excused.
Jurors excused. Like to step.
Mr. Isabel, according to the documents provided by the foreperson of this jury, we, the jury, unanimously find that the state has proven the following: aggravating circumstance or circumstances beyond a reasonable doubt. The murder was committed against a person less than 12 years of age, and the defendant was 18 years of age or older. We, the jury, unanimously agree that the defendant shall be sentenced to imprisonment for life. You will return to this court on October 31st for the status report on the remaining charges. As to count 2, life imprisonment. As to count 1 was an automatic life sentence. And we'll pick up on counts 4 and 5, the aggravated child abuse and the especially aggravated kidnapping, on November 12th for a sentencing hearing after receiving this pre-sentence report. Thank you. We are adjourned.
All rise. This court is now adjourned to 9 a.m. tomorrow morning. Raise your right hand.
Do you swear or affirm to tell the truth?
Yes, ma'am.
Please have a seat. Watch your step.
Would you state your name and spell it for the court reporter, please?
Madison Irwin, Madison Erwin.
By whom are you employed, Ms. Owen?
Inquisitor Incorporated.
And did you have a chance to work on the case of Brandon Isabel?
Yes, sir.
And how old was Brandon when this happened?
He would have, am I allowed to refer back to my notes?
Hearing no objection, go ahead.
Okay. He would have been 24 going on 25.
And did he work? Did he have a work history?
Yes, sir.
And where did he work?
At FedEx.
You know how long he worked there?
Approximately 4 to 5 years.
I have passed you up in your honor for the record of provided the state with the information that's in that format and moving evidence. During his work there at FedEx, did he receive any awards or recognitions for outstanding work?
Yes, sir.
What did he receive then?
He received the Purple Passion Award from FedEx. It's a certificate of excellence. He also received Employee of the Year for 2020, as well as a outstanding performance during the fiscal year of 2020 memorandum to the office.
And the letter that was provided to us, is that a letter from FedEx?
Yes, sir.
And would you read that to the jury, please?
Yes.
Relatively short.
Brandon, I truly want to thank you for your outstanding performance during fiscal year 20. Thanks for going above and beyond in all areas. Your positive attitude and great work ethics are appreciated. The extra hours, teamwork, and leadership that you've shown have resulted in overall operational effectiveness. Brandon, you have exemplified what the Purple Promise is about. It is employees such as you that make FedEx one of the most admired companies in the world. In recognition of your outstanding performance, it is with great pleasure that I present you with this Bravo Zulu for making a difference and keeping the Purple Promise. And this is from Jackie Nichols, the Managing Director.
Thank you, Your Honor. So, Your Honor, please, I'm going to ask that be made to exhibit the letter and the 2 certificates of excellence.
Collective.
Collective exhibit.
You'd like to identify this as collective work achievement? Yes, I will mark it. Thank you.
And during the course of time from the date of arrest to today, Mr. Isabel put in jail, have you had the chance to look at his jail records and see if he's completed any programs, has any certificates of completion of programs offered in the jail to better yourself?
Yes, sir.
What certificates of completion does he have?
He completed the electrical basics. He's also completed the master plan, and that's the first one, electrical basics, is from July of 2024. The master plan is from June of 2024. He has completed wellness recovery action plan. This is for reentry. That was completed in December of 2024. And finally, plumbing basics, that was completed in July of 2024.
Then I'd ask that they made the next cumulative exhibit, please.
For the record, your last exhibit was 195. This will be 196.
During your time of working with Mr. Isabel, has he been cooperative with you?
Yes, sir.
Also, did your investigation reveal that he has no criminal record, no criminal convictions?
Yes, sir.
Thank you. No other questions?
No cross judge.
Thank you. You may sit down. Mr. Massey, Mr. Hicks, do you have
No
anything
other
else?
questions?
Is that it?
Well, counts 2 and 3, you've already found Mr. Isabel guilty. So the state's aggravating circumstance is embodied in that finding of guilt. What we are here today, and this phrase "to decide," is what the punishment should be. Is life enough? 51 years? Or do you have to be, is this man so unable to be rehabilitated that he should be kept in jail the rest of his life? That's what you have to decide. And we'll be showing you evidence that, of course, he's youthful, he's worked, he's got good awards at work. While he's been locked up, he never made bond on this. So he's been in jail. While in jail, he's taken opportunities to better himself, taken classes that they offer there, and that brings Keisha back into it. One of the factors is that he acted under the domination of another. And so you'll get to consider that and give it what weight you consider to be proper in deciding whether it should be life or life without parole. Thank you.
You may be seated. It is my understanding that the jury has reached a verdict in the matter of the state of Tennessee versus Brandon Isabel. Is that correct?
Yes.
Will you please identify your foreperson? You've reached a verdict in this case.
We have.
Will you please pass up the file? Please silence all cell phones. Is this verdict unanimous?
It is.
By show of hands, please. Let the record reflect that all 12 of our jurors have raised their hands, indicating a unanimous verdict. When we began this process, I explained to you that this was a two-phase situation. I am going to give the verdict, and then you will have to report back to the deliberation room for the second phase, if necessary. What you'll discuss then with Deputy Moore is how late you want to go, or if you want to return in the morning, if necessary. Do you understand? Mr. Isabel, will you please stand? Mr. Isabel, a jury of your peers has found you guilty of the first-degree premeditated murder as charged in count 1 of the indictment. Mr. Isabel, the jury has found that you guilty of the first-degree murder premeditated killing as charged in count 2. Mr. Isabel, we the jury find the defendant guilty of first-degree murder killing in the perpetration of aggravated child neglect as charged in count 3. Mr. Isabel, as to count 4, we the jury find the defendant guilty of aggravated child neglect as charged in count 4 of the indictment. And Mr. Isabel, we the jury find you guilty of especially aggravated kidnapping as charged in count 5 of the indictment. I will ask the jury to retire to.
Jurors excused, like
The
to
jury.
step.
It is now 5:33. Strike that 5:31. We will begin our second phase at 6:00 p.m. should the jury show decide to go forward tonight. Recess.
Stand for recess.
Does the state of Tennessee wish to make or give a closing argument?
Yes, Your Honor.
Go ahead, please.
Kennedy Hoyle should be 3 years old. She should be growing, learning, getting into things, driving her mom Danielle and her grandma April crazy. She'd be too big for this car seat, but she's forever frozen in time, not even 2 days old, along with her mother, Danielle. They're gone because of that man, Brandon Isabel. He shot Danielle 5 times and left her in a ditch. He took baby Kennedy, drove her to the river, and tossed her in the cold, dark water. Ladies and gentlemen, you've heard all the proof that you're going to hear in this case. You've now heard the law given to you by the judge. You have 5 counts, and they're listed up on the screen for you. Now, you'll see in your jury instructions that there are lesser included offenses for each count. That is not a menu. You don't pick and choose. You have to start with the top charge. So in count 1, that'll be first-degree murder. Everyone has to agree that he's not guilty of first-degree murder before you move to a lesser count. Now, let's talk about count 1 and count 2. Talked about in voir dire elements, what the state has to prove beyond a reasonable doubt. You have count 1, which is premeditated first-degree murder as to the death of Danielle Hoyle. You also have count 2, which is premeditated first-degree murder as to the death of Kennedy Hoyle. The elements are the same. First, the state has to prove that Danielle and Kennedy were unlawfully killed, that the defendant acted intentionally, he intended to kill them, and he acted with premeditation. Now, in your jury instructions, intentionally is defined. It wasn't an accident. The defendant, he pointed that gun at Danielle and fired it at her, intending to kill her. He took Kennedy by the leg and threw her into the river. He intended to kill her. Now let's talk about premeditation. You have the full definition in your jury instructions. And you notice that it talks about reflection and judgment, but that there doesn't have to be a specific amount of time with regards to forming the intent of the purpose to kill. So, how did the state for counts 1 and 2 prove premeditation? The planning. Think about everything that you've heard over the course of several days. The defendant, he filed for divorce January 27th of 2022, mere days before he killed Danielle and Kennedy. What else? Kennedy is born January 31st of 2022. The defendant doesn't sign her birth certificate. Then we move to January 30th of 2022. And you heard Special Agent Garner tell you that they went through the defendant's phone. And what did they find? Web searches. 2 days out from the murder, and the defendant is searching Jared in the wedding ring section. And then he had some additional searches. Can all bullets be traced back to the exact gun that fired them? Can you tell what gun a bullet came from? Now let's move to February 1st of 2022. And you heard Special Agent Garner tell you that he was able to tell the defendant's movements throughout that day. And earlier that day, he's on Mart Road. And you heard Investigator Byers tell you that Mart Road is along Lakeview. And it's an easy turn to miss in the dark. And if you notice on the map, you take Lakeview and you miss Mart Road, next turn, Sedgwick and Levi. Dark, desolate, deserted. Now the defendant told us in his confession, and his GPS told us, he met Danielle at the MAPCO. And why? He told her he had baby clothes to give her. And what was found in the defendant's white Chevy Malibu? Baby clothes. And then we get to the scene. Levi and Sedgwick. He gets Danielle to meet him at that MAPCO. He convinces her to drive down Levi and Sedgwick. No lights, dark, quiet, raining. And he tells us in his statement that he had car trouble. Think about the scene at Levi and Sedgwick. Danielle's Chevy Cruze parked on the wrong side of the road. And what did the defendant tell us? She got in position to shine her headlights to help him out with his car trouble. And what did he do? He walked up to her Chevy Cruze. He opened the passenger door and he fired. 1, 2, 3, 4, 5 shots into that car, striking Danielle 5 times in the face and head. premeditation. Now by 9:23, according to his GPS, he's moving on. He's leaving the area of Levi and Sedgwick. And who does he have with him? He has baby Kennedy. And while Kennedy's in the car, and he has left her mother dead in a ditch on the side of the road, he's covering his tracks. He's sending text messages to Danielle, knowing that she'll never answer. Now, he's been driving around. We're at about an hour. Kennedy's been in the car. And he stops off at home to get out of his murder outfit, those Adidas slides, that windbreaker-like jacket, the black and the greenish blue. Takes the time to hang that jacket in the closet. Comes back out, gets back in his car, and what does he do? He drives to Mud Island, all the way from Cordova, passing numerous exits, numerous houses, places. All that time, could have made a different choice. But he went, and he drove on Island Drive to get to Mud Island, to that boat ramp, and he took baby Kennedy by the leg and threw her into the Wolf River. Count 4, we're going a little bit out of order, is aggravated child neglect. And you can see the elements for aggravated child neglect, what the state has to prove beyond a reasonable doubt. That the defendant knowingly neglected Kennedy so as to adversely affect her health and welfare, that it resulted in serious bodily injury, and that Kennedy was 8 years of age or less. And there you have the definition of knowingly, as well as serious bodily injury, all defined in your jury instructions. What did the defendant do with Kennedy? He took her down to the boat ramp at Mud Island. In the dark, in the cold, in the rain, out of her car seat. And even if you believe that he didn't throw her in the river, he just left her by the river and she somehow managed to go into the river, he is still guilty of murder and perpetration of aggravated child neglect. Serious bodily injury or death. Adversely affect the health and welfare. He left her where she could fall into the river in the cold and the dark and the rain. And as you see, that goes hand in hand with count 3, and that's the murder and perpetration of aggravated child neglect. So in that count, the difference is the defendant didn't have to intend the killing. He had to intend the aggravated child neglect. Last count, especially aggravated kidnapping. You can see the elements. What do we know? The defendant, after shooting her mother, takes Kennedy, takes her from Levi and Sedgwick, drives around Cordova, goes to his parents' house, goes all the way down to the river, and kills her. The state has to prove identity. How do we know that the defendant, Brandon Isabel, is responsible for each and every one of these crimes? He told us. You listened to his interview with police. He told us. He told us exactly what he did. We have the GPS that Special Agent Garner went through methodically, telling us all the points of where he was located throughout that day and night. His phone, a silent witness to those murders. The text messages. And you'll have those text messages between the defendant and Artesia. They're going back and forth throughout the night. And why is that? Is it because they're in two different locations? They're not together? And there's the shell casings. The defendant, he told us, he shot Danielle with his 9mm. What do we find? 9mm shell casings in the passenger seat of Danielle's car. 2 in front of her car. And a loaded 9mm magazine in the defendant's white Chevy Malibu in the center console. And he told us what he did with Kennedy. That he took her to the boat ramp, took her by the leg, and threw her into the river. And what did he say in his statement? It didn't go as far as the gun. And what did officers find on that boat ramp? Kennedy's baby cap. Why'd he do it? What's the motive? You'll notice that is not an element that the state has to prove. But it's pretty clear, the motive here. And it's Artesia. The defendant wanted to be with Artesia. You heard her testimony. You've heard the text messages. She didn't want to have to deal with another child on top of her child, on top of the child the defendant already had, another mother in the mix. And so he came up with this plan. And he never wanted that baby. And you can see in that text message that he had sent to Danielle, what does he say? I can't be a father to that kid right now, Danielle. If you love me like you say you do, then let's end our mistake, Danielle. But Danielle wanted to be a mother to that little girl. That little girl wasn't a mistake. Now let's fast forward to January 30th of 2022. And you heard the text messages between Artesia and the defendant. And this is in the late night of January 30th. What we know is that Danielle's already at the hospital, and she's in labor, about to give birth to baby Kennedy. And what is the defendant texting? He's texting to wifey, Artesia, I love you. Baby, say it back. You doing this to me in a time like this? And what does Artesia respond? Tell her have a safe delivery. I'll talk to you when y'all get the results. Then we move in to those early morning hours, right around the time that Danielle is giving birth to Kennedy. And what is the defendant doing? He's still texting Artesia. He's still sending her messages over and over again. And what is Artisha's response? I'm going to make this simple. If it's yours, build that bond. Get to know her as a woman because she loves you as well. I won't need no response. Silence will answer that for me. If it's not, we still need space to take this relationship slow. She's slipping away. His perfect woman is slipping away. And what does he do? While his baby has just been born, he's still sending text message novels to Artisha, professing his love. And they're still going back and forth. And he says to her, "This the worst I've acted over a female. Never wanted somebody so bad. You knew this day was coming. Why wait until now and all this love and time?" And then what do? That early morning, after Kennedy is born, they agree to meet up. And where does the defendant suggest? Where you want to meet at? Our river spot? Now we're at February 1st of 2022. 7:58, the defendant gets back to his home on Lathbury. Then he's gone again at 8:05, and he's dressed to kill. According to the GPS data, he's at the MAPCO at 8:32 to 8:51 p.m. And he says that in his statement to Sergeant Boyd and Sergeant Wimbush. He met Danielle at the MAPCO. And we found the baby clothes in the Malibu. Now we're moving on. Between 9:02 and 9:23, GPS has him at Levi and Sedgwick, and he admits to going there. And during this time, he and Artisha are still going back and forth. And you'll notice that from 9:04 to 9:22, he stops texting Artisha. All those blue messages, Artisha. Green messages, the defendant. And what is he doing in that gap in time, that 9:04 to 9:22? He's shooting Danielle 5 times in the head and the face and taking her sweet, precious baby and driving away. You see what's left behind. Danielle and those 9mm shell casings. And he drags her, and he tells us how he drags her out of that vehicle by the shirt. And look at her clothes. Look at how her jacket is pulled off her body. He killed Danielle. He left her in a ditch. He's driving around with Kennedy in his seat. He's texting with Artisha. And he takes the time to put in a food order. Cheeseburger, no onions, blue Kool-Aid. And what did Artisha tell us? That she stopped by Dixie Queen that night. And what did we find in her car? Looks a bit like a blue Kool-Aid. Now, we're back at 8702 Lathbury. Gets there at 10:24. You can see what he's wearing. You see those Adidas slides, those black socks. Goes inside, takes the time to hang up his jacket, changes his clothes, and he's gone again at 10:29, holding that blue bag. Baby Kennedy in his white Chevy Malibu. And what do they find in the trunk of that white Chevy Malibu? Those Adidas slides. And looks a bit like that blue bag he was carrying on the Ring camera footage. Where's he headed? Island Drive. And how do we know that that's the defendant? You heard Lieutenant Stanley testify that they had license plate reader hits on his tag going over the A.W. Willis Bridge. They were able to look back at camera footage from the Real-Time Crime Center, and they see that white Chevy Malibu driving up and down Island Drive. 10:59 to 11:20. And all that time, from leaving Levi and Sedgwick to 9:23, all the way to Island Drive, could have made a different choice. He had every opportunity to make a different choice. And we're at 10:54, right before he gets to Island Drive, and he's texting with Artesia. And what does he tell her? He tells her he just left the house. But we know he's down on Mud Island, getting rid of the last obstacle between him and Artesia. And at 11:13, right before he takes baby Kennedy and throws her into the river, he wants to know when Artesia's going to be around. 11:20 to 11:27. He's at the boat ramp, GPS. And he says that he threw the baby by the leg. And you'll have his interview. Notice that Sergeant Wimbush, he says he threw the baby by the arm, and it's the defendant that corrects him and says by the leg. Sergeant Boyd asks, how far into the water did you throw her? And his response, it wasn't far. It didn't go as far as the gun. And now, baby Kennedy is in the Wolf River. Danielle is in a muddy ditch on Levi and Sedgwick, being discovered by Officer Sutton. And what's the defendant doing? He's at Walgreens, buying stuffed animals, roses for Artesia. And writing a card professing his love and talking about raising Kennedy, who he knows he just threw in the Wolf River. And how do we know? Because we have video. We have GPS. And the defendant told us. Now, while we're at the Walgreens, what's going on? Texting Artesia. And what did she say? She said he shared his location, which wasn't normal for them. And she called him out on it in the text messages. And where did she say that location was? Walgreens. Is he trying to set up his alibi? Because he's also out there in the parking lot, and you can see it in the video, sits there for a while. And what's happening? Prior to arriving at Walgreens, he's sending text messages, once again, to Danielle. 11:39. Show me Kennedy. I'm going to take her tomorrow. After not half an hour before throwing that baby into the Wolf River. 12:02. Give her a kiss for me. Just miss her. That's all. Love y'all. At 12:13, sends Artesia another text. Now he's on the way to Walmart. And what does he tell Artesia? I want to cuddle tonight. I ain't slept with you in a week. And then we arrive at Walmart. How do we know? GPS, video, and the defendant tells us. And he tells Sergeant Wimbush and Sergeant Boyd. He left the car seat at the Walmart. And Officer Blake, that's where he finds it. And what does he find? Finds the car seat. And then you heard from Officer Walker, a mitten. A matching set. The riverbank and Walmart. Then he goes to Stacy Road. And again, his GPS puts him there. Artesia puts him there. He's coordinating meeting up with her. And what is found in his Chevy Malibu? An empty gun holster, a 9mm magazine, and gloves with the cockle burr. And then by 1:07 a.m., he and Artesia are back at his house at Lathbury. Let's talk about the gun. There's been a lot of talk about Artesia had a .40 and a Smith & Wesson, and there was .40 caliber rounds found at Levi and Sedgwick. You saw how many rounds were found of various calibers at Sedgwick. You saw, when you zoom into that picture, that street sign that was covered in bullet holes. You heard Investigator Byers' video, and he said that jingling noise that you could hear were shell casings. But what shell casings were found in Danielle's passenger seat? 9mm. What shell casings were found just up from the car? 9mm. What magazine was found in the defendant's center console of his white Chevy Malibu? 9mm. And if you look closely, from in front of the Chevy Cruze, Hornady shell casing. In the passenger side of Danielle's vehicle, Hornady 9mm shell casing. And in the defendant's car, live rounds, Hornady 9mm. And what did the defendant tell us he did with the gun? He threw it in the river. What did we find? We didn't find the gun, but we found his gun box. And what was in that? More magazines for a 9mm. What gun did we find? We found Artisha's gun, a .40 Smith & Wesson. It wasn't missing. It was right there. And then you look at the scene at Levi and Sedgwick, and you can see, and those are placards 12 and 13, those are those two shell casings from a 9mm in their Hornady brand. And what did the defendant tell us in his statement about what happened? After he shot Danielle, the car rolled. And you can see a pile of glass fairly close to those 9mm shell casings. And you can see Danielle's car in the distance, as if it had some time to reflect. Oh, Danielle was an accident. Ladies and gentlemen, you heard Dr. Collier. Danielle was shot 5 times. In the head and in the face. This was not an accident. This was a premeditated execution. Then we have the DNA, the Adidas slide, seen on the defendant that night in that Ring camera video, found in the trunk of his white Chevy Malibu. And what did he tell officers about that during the interview? He said that Danielle's blood would be on the slides. He even specified which one, the left. And which one had Danielle's DNA, according to Agent Walzak? The left. And then he sits through that interview the entire time wearing those white socks with Danielle's blood on them. And you saw that he had a pair of black socks over them. And that blood had seeped through to those white socks. But Officer Carlisle found them. They went to the TBI to be tested, and once again, Danielle's blood on those socks that were on the defendant's feet. Ladies and gentlemen, the term victim is used a lot. But Danielle and Kennedy were more than that. Danielle was a mom. She was 27 years old. She was a girl mom. She had 9-year-old Jariah and her new baby, Kennedy. And then there's Kennedy, who will forever be, frozen in time, less than 2 days old, never getting the chance to grow up. Danielle's mistake was getting involved with that man. Danielle and Kennedy. they'll never do so many things. And it's because of what the defendant, Brandon Isabel, did. Ladies and gentlemen, the state asks that you find the defendant guilty of every single charge of the indictment. Thank you.
Case number 23 CF 983. Appearances.
Christy Gordon for the state. Good morning, Judge.
Good morning.
Good morning. Attorney Brianne Bucher and Attorney Ron Sonderhaus appear on behalf of the defendant, Amy Laskowitz, who also appears.
All right, thank you, and good morning.
Morning.
I have a plea questionnaire that indicates the defendant is proposed to enter a plea of guilty to the charge in count 1 of the information. True?
Ms. Laskowitz is planning to proceed with an Alford plea.
All right, now I see that. All right, very good. So tell me what the basis of the Alford plea is.
Sure. So I've been in many conversations with Attorney Gordon. She did extend an offer that my client wishes to take advantage of. My client also disputes that she is guilty. However, she does feel that the state does have enough evidence wherein she could be found guilty at jury trial. So in order to take advantage of the state's offer, this is how she wishes to proceed.
Are you satisfied there's overwhelming evidence of guilt?
I am, yes.
May I use the criminal complaint as a factual basis for the plea?
You may.
Now, how many attorneys are speaking at the hearing for the defense? Is Attorney Booker going to be?
I can be the one that speaks, that's fine.
That's fine.
All right, so then from your standpoint, Attorney Booker, may I use the criminal complaint as a factual basis?
Yes.
State offers it.
Yes, please.
Ma'am, have you read the criminal complaint? I got to hear you, so you got to speak up.
Yes.
And are the statements in the complaint substantially true and correct?
I didn't hear that.
Are the statements in the criminal complaint substantially true and correct?
The state believes that but I don't, I feel I'm innocent. I didn't cause what they feel.
No, that's not what I asked.
Okay.
Now, the complaint contains factual statements or allegations of things that happened to your daughter. True?
True.
Now, some of the things that happened to your daughter are, from a physical standpoint and from an examination standpoint, are circumstances. I would tend to think they exist. They existed in there. That's what the various exams found. So you disagree with the legal conclusions that are drawn from those circumstances, true?
Yes.
You know, this is, you know, I can't lead the defendant through the plea. I understand this. The defendant's a reluctant person in entering the plea. And I understand the basis of the Alford plea. But I can't lead the defendant through it. So I'll put the matter over to this afternoon and have so she has a chance to review the matter with her attorneys, and we'll go forward from that standpoint.
I don't understand.
Go ahead. The only one, you know, my practice is when there's multiple attorneys representing a person, only one attorney does the speaking.
Could I have a moment to speak with Attorney Sanderhouse?
You may.
Thank you. Right, I understand the court can't lead the defendant through the plea colloquy, but I am confident that she does disagree with the legal conclusion. She understands, and she does agree with the facts as laid out in the criminal complaint. If the court's still not confident that that's the case and feels that the court is having to lead Ms. Laskowitz through the plea colloquy, I understand if we would need to come back this afternoon, but I'm just requesting that we try to get through the plea one more time if it meets with the court's approval.
Well, I'll ask the question, are the statements in the complaint substantially true and correct?
Yes.
All right. Now let me read the charge to you. The charge states that you did on or about Wednesday, January 4, 2023, in the city of Pewaukee, Waukesha County, Wisconsin, did recklessly subject an individual at risk, victim A, to abuse under circumstances that caused the death of said person, contrary to Wisconsin law. You understand that's the charge?
Yes.
And understand that what I read to you would be the elements of the offense. That's what the state would have to prove beyond a reasonable doubt if your case went to trial.
I didn't hear that. I'm sorry, I didn't hear you.
All right. Do you have any hearing? I don't know. I may be speaking softer today, but
She's had trouble hearing me as well, so I don't know if maybe a headset would be
I get a little
helpful.
nervous.
well, we'll give you a set of headphones.
It'll be better.
Now, let me read the charge to you. Can you hear that better?
Yes.
Okay, the charge is that you did on or about Wednesday, January 4, 2023, in the city of Pewaukee, Waukesha County, Wisconsin, did recklessly subject an individual at risk, victim A, to abuse under circumstances that caused the death of said person, contrary to Wisconsin law. You understand that's a charge?
Yes.
And you understand that what I read to you would be the elements of the offense. That's what the state would have to prove beyond a reasonable doubt if your case went to trial.
Yes.
Now, you know further that the maximum penalty the court can impose upon your conviction of that offense is a fine of not more than $100,000, imprisonment for not more than 40 years or both.
Yes.
I understand on the maximum sentence of 40 years imprisonment, that means 25 years of initial confinement, 15 years of extended supervision. Does the state have a recommendation for disposition?
Yes, Judge. As part of the plea agreement, the state agreed to cap the recommendation at 15 years of initial confinement, and both sides will be free to argue as to the length and terms of extended supervision.
All right, thank you. Attorney Booker, is that your understanding of the state's recommendation?
That's my understanding of the recommendation, yes.
And ma'am, is that what you understand the state to be recommending? Now, you know that at sentencing, I listen to what the state recommends. I'll listen to what Attorney Booker and other attorneys that represent you recommend. I'll listen to what you say about the case. But at sentencing, I don't have to follow any recommendations. I can impose a sentence up to the maximum we talked about a few minutes ago. It shows that you signed it on December 30th.
Yes.
So that means you met at Attorney Booker's office on that date?
Yes.
And she went over the plea questionnaire with you?
Yes.
Did she go over it with you by reading it to you?
Yes.
And were you able to follow along as she read it?
Yes.
Did she read the entire document to you?
Yes.
Did you understand everything?
Yes.
Everything in it is true and correct?
Yes.
In addition to the plea questionnaire, she's also attached a jury instruction 1268, abuse of individuals at risk, and she read that to you as well?
Yes.
Now, the jury instruction is the form jury instruction. It contains a number of areas that are crossed off, true?
Yes.
So she read to you the parts that aren't crossed off.
Yes.
When you understood everything, is that when you signed on the second page of the plea questionnaire?
Yes.
And you also placed your initials next to the jury instruction on the elements of the offense?
Yes.
So the plea questionnaire tells me that you're 53 years old,
Yes.
12 years of schooling with a high school diploma.
Yes.
Any post-high school education?
Yes.
What do you have?
A bachelor's in business.
Okay, and are you employed?
No, not currently.
When you are employed, what did you do?
I worked at Liberty Mutual in underwriting.
And doing what?
I was an associate underwriter.
All right, how long did you do that?
Many years.
Well, 20, 10?
13 there, and I worked in insurance before that, so.
All right. When did you leave the Liberty Insurance?
When my husband died,
So when was that?
2012. I haven't been employed since.
Do you have and do you understand any difficulty understanding the spoken or written English language?
No.
Do you receive treatment for any mental illness or mental disorder?
No.
Do you take any medications?
No.
In the last 24 hours, any alcohol?
No.
Any other kind of drugs?
Any other what?
Any other kind of drugs?
No.
Do you understand that if you're not a citizen of the United States, your plea could result in deportation, the exclusion of admission to this country, or the denial of naturalization under federal law?
Yes.
Do you understand that the offense to which you're pleading guilty is a felony?
Yes.
Because it's a felony upon your conviction, you know that you'll not be able to own or possess any firearms.
Yes.
Further, you'll not be able to vote until your civil rights are restored. Understand that?
I will not be able to what?
To vote until your rights are restored. Do you understand that?
I didn't, but now you're telling me, so, yes.
Yeah. Any questions about that?
No.
Now, I'd like you to look, do you have a copy of the plea questionnaire in front of you?
Yes.
You have the orange copy?
Yes.
All right, I'd like you to look at the first page, center section.
Okay.
It says constitutional rights. You see that section?
Yes.
Now, Attorney Booker read that section to you.
Yes.
When she read it to you, she explained that what's listed there are the rights that you give up.
Yes.
And as she read those to you, did you place your initials next to each of the rights?
Yes, I did.
So you understand what your rights are and then what the rights are that you give up when you enter a plea.
Yes.
I'm just going to review those rights with you.
Okay.
The rights that you give up then are your right to have a trial.
Okay.
Trial could be in front of a judge only or in front of a jury of 12 people who'd have to decide unanimously if you were guilty. You give up your right further to remain silent and not have your silence used against you.
Yes.
You give up your right to do the opposite of that, and that is to testify at a trial and present evidence. You give up your right to have subpoenas issued to require people to come to court for you. You give up your right to confront, cross-examine, challenge witnesses brought in by the state, and you give up your right to have the state prove that you're guilty beyond a reasonable doubt.
Okay.
You understand all of those rights?
Yes.
And you give those up.
Yes.
Now, have you had enough time to talk to Attorney Booker?
Yes.
Now, in your conferences with Attorney Booker, have you also met with Attorney Sonderhaus?
Yes.
Have you conferred with him?
Yes.
Are you satisfied with the representation you've received from both Attorney Booker and from Attorney Sonderhaus?
Yes.
Need any more time to talk to either one of them?
I don't know. No.
Well, you seem quizzical. Do you have questions that you...
I don't. No, I don't.
Okay, so you don't have any questions for your lawyers?
No.
Are you satisfied with both Attorney Booker and Attorney Sonderhaus as your lawyers in this case?
Yes.
Then Attorney Booker, are you satisfied that Ms. Leskiewicz's plea today is a voluntary, knowing, and intelligent plea?
Yes.
And Attorney Sonderhaus, are you so satisfied as well?
Yes, Judge.
So I'm going to go back to the charge then, and I'm going to read you the charge, ma'am, then I'll ask what your plea is. So the charge is that you did on or about Wednesday, January 4, 2023, in the city of Pewaukee, Waukesha County, Wisconsin, that you did recklessly subject an individual at risk, victim A, to abuse under circumstances that caused the death of said person, contrary to Wisconsin law. You understand that's the charge?
Yes, I do.
And what is your plea?
I plead the Alford plea.
So you're pleading guilty under the Alford case.
Sure.
Would one of the attorneys consult with her so she...
Yes.
What am I doing? I'm taking the Alford plea, or I'm not saying this right.
I'm pleading guilty under the Alford standard.
I'm pleading guilty under the Alford standard.
All right, thank you. I'll accept that. And on that plea, I'll accept the Alford guilty plea. And I'm satisfied that the requirements of an Alford plea have been satisfied through the nature of the case and the court's review of the circumstances. I'll accept the guilty plea. I'll find the defendant guilty of the offense charged, and I'll enter a judgment of conviction. So ordered. Now, how are we proceeding to sentencing?
So the state, I believe both of the parties were asking for a separate sentencing date, but the state is asking to address bail following the entrance of the plea.
All right. Thank you. So is there a request for a pre-sentence?
Yes, we will be obtaining a private pre-sentence investigation report.
Is that what I asked? Is the defense requesting the court order a pre-sentence?
No.
All right, there you go. All right. So sentencing about an hour?
I think that's reasonable.
I think so as well.
I agree.
Okay. How long will it take for the defense pre-sentence to be prepared?
45 to 60 days.
So, all right, so then we need to go out at least 2 months.
Do March 3rd at 9 o'clock. Are there any other times available? I have a status hearing, but I think it'll be probably 15 minutes tops. So I don't know if we could do 9:15 or 9:30. Not that day, no. I do have March 6th at 10 o'clock.
I may be in trial with Judge Melvin.
Well, who's handling the,
I'm likely to be in trial that week as well. I have 3 trials scheduled, so the likelihood is high.
so who's handling the sentencing?
We have not discussed who's going to be making the sentencing arguments, but we both would like to be present. Ms. Laskowitz would like you.
Well, that's fine, I understand that concept, but I can't, we can't get involved in trying to pick an availability date for all the attorneys involved when there's one attorney should be representing the defendant. So if we can accommodate both attorneys, we'll do so, but otherwise we'll have to go with one.
I understand. March 21st at 9:30? That's fine.
Yeah, that's fine.
So that's good.
Yes.
All right, very good. Then, ma'am, just so I know the state's making a request, you're still in Christian Lane?
Yes.
And phone number still ends in 53? All right, thank you. What's the state's request?
Thank you, Judge. The state is asking that bail be revoked and that the defendant be remanded into the custody of the Waukesha County Jail. As the court heard, the state's recommendation at sentencing is 15 years of initial confinement. She no longer has the presumption of innocence. She certainly now has some reason to flee the jurisdiction of this court, having now pled guilty, even through a no contest Alford plea. But having been found guilty by the court and knowing that she is facing a significant prison term, I believe that given the facts of this case, that a remand is appropriate and that a prison sentence is likely in her future.
All right, what's the defense position?
Thank you. Just a few points that I would ask the court to consider. Ms. Laskowitz is 53 years old. She has no prior criminal history. She's a Waukesha County resident. She's made each and every court appearance, and since the day that this was charged, she was facing 40 years in prison, and she's come to court every time. She's not had one bail violation, absolutely nothing. She does have a 23-year-old daughter who lives with her. Her name is Sarah. She relies on her emotionally, financially.
Who relies upon who?
Her daughter relies on Ms. Laskowitz. She lives with her. I understand what the state is saying. However, I think based on the fact that this case is over 2 years old, the complaint was filed back in June 21st, 2023. So that's a year and 7 months based on my math. And Ms. Laskowitz, I don't believe has given the court any reason to believe that she is a flight risk. She's been in communication with us. She's here today. She's taking this matter seriously. She's hired not one but 2 attorneys. So based on her history, the fact that she has no violations, and all of the other reasons that I've stated on the record,
I am asking the court to consider leaving bail as set.
What is bail?
The bail that she posted was, I believe, $10,000 cash. And that was posted back in June of 2023.
All right, thank you. Yeah, I'm satisfied that Ms. Laskowitz is not a flight risk based upon the history in the case. And I understand that she's lost the presumption of innocence, which abides during the pretrial activities, but I'm also satisfied that we haven't come to the sentencing yet, and I'm satisfied that under all of the circumstances, the court will permit bail to stand as it is so ordered. Then that should conclude everything today.
Thank you, Judge.
Thank you.
Have a good day.
Happy New Year.
Happy New Year.
Defendant is guilty of the following: count 1, first-degree murder, a class 1 felony and dangerous crime against children, committed January 20th, 2020. Count 2, first-degree murder, class 1 felony and dangerous crime against children, committed January 20th, 2020. That is victim B. Count 1 is victim A. Count 3, first-degree murder, a class 1 felony and dangerous crime against children, committed January 20th, 2020. Victim C. All are dangerous but non-repetitive offenses under the criminal code. In preparing for sentence, received and considered all of the following: the pre-sentence report, which includes some reference to victim next of kin, the requests and restitution amounts, the recommendation from pre-sentence report, which is in line with the stipulations of the parties in the plea agreement, the written separate statement by victim aunt in this matter, the defense sentencing memorandum and any attachments, the state's sentencing memorandum, the defendant's criminal history, which is non-existent prior to these offenses, as well as the stipulations of the parties in the plea. This is a stipulated specific sentence. Does the state have anything they wish to add for sentencing, or do next of kin wish to make a statement?
I don't believe anybody's going to make a statement today, Judge, so
Okay.
it's just going to be me. Before I make my statement, I do know...
Just pull a microphone.
Absolutely. Sure. There is a restitution request, Judge, for $30,000 from the MCAO Compensation Bureau, so I didn't know what the defense's position was on that.
Judge, we would request a hearing on that. We would like to see the receipts on that.
Okay, what I'll do is I'll retain jurisdiction, and then I won't set anything today. If you guys aren't able to work something out, I will set something at that point.
My only thing I would add, Judge, is we've provided all the documentation to the defense, and so I don't know if they haven't reviewed it. We did get some emails from Ms. Warner about it, so I thought they had reviewed that, but if they're not going to stipulate, then maybe we just set a hearing.
Okay, I mean, I'm happy to set a hearing today. It's going to be a little bit, because of my schedule currently, my Fridays are full, but so.
I understand.
That's fine, Judge, and Ms. Henry will waive her presence for the purpose of the hearing.
Okay, thank you.
Judge, I'm going to be brief because obviously we did file a sentencing memo and it is a stipulated sentence. I would note, Judge, for the court that it is probably hard to find somebody who had a role in this case who hasn't been affected by it. I would put obviously the family and friends in there. You read the letter from the victim's aunt talking about how this has affected her, how it's affected the children's father. Obviously there's friends that have been affected by it. It has had an effect on the police officers and the fire and medical personnel who responded to that scene that day. A lot of the fire personnel thought, because there was a miscommunication, they thought it was a drowning call. They thought they were responding out to a scene to try to save children, and when they got there, found out that there were already 3 dead children inside of the house when they got there. I know the defense noted this in their sentencing memo. I think we noted it in ours. Some of the personnel, the first responders, are still in therapy. and have been affected by what happened, even though this was 5 years ago. I would add attorneys to that list as somebody who himself responded out to the scene that day. Why this has had effect on so many people involved in this case isn't really a surprise. It's because the 3 victims, Zane, Maria, and Catalaya, are 3 innocent children, all under the age of 4. The defendant is obviously going to prison for the rest of her life because she did the unthinkable in this case, Judge. She had a duty to protect her children from anyone or anything who would try to harm them. But unfortunately, in this case, she was that thing. These 3 children in this case were completely helpless to protect themselves from her, to stop her from what she did to them that day. And all 3 of these murders against Zane, Maria, and Catalaya were senseless and, quite frankly, cruel. The defense noted in their sentencing memo that she is going to have to think about this and the effect that it's had for the rest of her life, and I hope she does, because she took the futures of 3 children away from them that day when she did what she did. In terms of the mitigation, Judge, I'm not going to touch much on it because I think the defense will articulate it better than I will today. I would note that the defendant, Ms. Henry, took responsibility for this when she admitted to the police what she did that day when they interviewed her, and she's obviously taken responsibility now when she entered into this plea agreement for natural life in prison. In terms of the other mitigation that's in the defense's sentencing memo, and I'm sure they'll talk a little bit about today, that is all information that our office took into consideration, Judge, when we made what was a very difficult decision in this case to come to this plea agreement and to not go forward, obviously, with the death penalty. Based on everything, Judge, we do believe that this plea agreement is in the interest of justice. We are asking the court to accept the stipulations in the plea agreement and sentence the defendant to 3 consecutive sentences of natural life in prison. And that is based on, obviously, the aggravating and the mitigating factors, Judge. Is there anything else? That's all I have. Thank you.
All right, thank you. Mr. Tavazzoli?
Thank you, Judge. May I remain seated
Yes.
for my comments? Thank you. First of all, I would like to express my deepest sympathies, condolences for the loss of Zane, Maria, and Catalaya. They were so young and their lives were tragically taken from them. I am personally deeply sorry for their loss, and Rachel is as well. This is a tragedy of monumental proportions, and we are here on this solemn day to give this tragedy a final resolution. Next, I would like to say that we believe the sentence in this case is appropriate. We can never bring back the lives of these 3 children, but Rachel is ready to begin to make up for this unfathomable loss of her children by spending the rest of her life in natural life in prison. It is no small sacrifice, but it is one that she's willingly and sorrowfully accepting as she's entered into the plea agreement. This begs the question, why did this happen? Ms. Warner and I have had this case for 5 years. In that time, we have explored different theories in the case and have concluded there were a variety of factors that led to this tragedy. And had any of these factors not occurred, it may have prevented the deaths of these children. There was strong evidence of postpartum depression, mood disorder, dissociation, severe depression, fetal alcohol spectrum disorder, and that can explain some of Rachel's mental state at the time. Her social history, much of which was provided to the court and is incorporated into the sentencing memo, is also another clear factor. And the complete lack of support that she experienced at the time of the offense is another factor, Judge. However, even though we've investigated this case, it is still kind of a mystery in the sense that we may never know exactly what was going on that day with Rachel. And Rachel can't explain it or remember it herself in any articulable way that can make sense to herself and to everyone else. It's important to note that this is an explanation for these horrible offenses and not an excuse. In no way does it justify what she's done. For those people that have only a fraction of the information about her case in the media, not knowing anything about who she is, and who have tried to capitalize on her case, I would like to say that she will be punished for the rest of her life. Not only will she be imprisoned and given no chance to get out, but she will live with the knowledge of the gravity of her offenses and must live with without the loving presence of her children for the rest of her life. It's also important to note that up to the time of their deaths, Rachel was always described as a loving mother. In the time that we have represented her, she's always been kind and thoughtful, providing us all with origami figures she's made for us, me and my staff. Equally important is the fact that in the 5 years that she's been in the Estrella jail, which can be, it's described as kind of a junior high school on steroids, she hasn't received one ticket for misbehaving, and that's nothing short of a miracle in there, Judge. Especially with Rachel being diminutive, she's an easy target for bullies and other behavior, negative behavior that's directed toward her, particularly in light of the charges. Like I said, the sentencing memo that we provided to the court covers the vast majority of our mitigation, so I won't revisit those in these remarks. I do want to say that I do believe Rachel has accepted her responsibility and her fate, and she's ready to go to prison and try to be a positive influence in that world, even though it's going to be a restricted life that she's going to lead. And finally, I'd like to thank Chris and Jesse from the Maricopa County Attorney's Office and Catherine Ferguson Gilbert, who was on the case before, for helping us to resolve this case in a very appropriate way. I think they were very fair and professional in the course of our relations with them. I also want to acknowledge, as Mr. Sammons has said, that there were a lot of first responders that were affected by this case, severely traumatized. Finally, I'd like to acknowledge that because it affected the law enforcement, not only, I think Chris kind of mentioned this, but everybody was affected by this case. Law enforcement, the firefighters, even your court staff, this court, our defense team and the attorneys, the county attorney's office, everybody who's touched this case has been affected by it. We're forever changed by the deaths of these children, and life will never be the same for those, for the lives that their lives have touched. So with all that said, Judge, we ask that the court follow the recommendation in the plea agreement and sentence Rachel Henry to 3 consecutive natural life sentences. Thank you.
Okay, thank you. Ms. Henry, is there anything you wish to say?
No, Judge.
Oh, okay. Any legal cause?
No, Judge.
All right. Let me get a hearing on the restitution first, and then I'll pronounce sentence. How long is the hearing itself going to take, if it goes, do you think? An hour at the most?
An hour at the most, Judge.
So April 25 is, hold on a second. I'm sorry, I could do April 4 at 11 o'clock. That works.
That works for us.
Let me double check my calendar. Your
Sure.
Honor. It's always on the slow. That's fine, Your Honor. Thank you.
Okay.
Yeah, that's good, Judge.
All right, and obviously if there's an agreement to something, we can vacate that. So it's ordered setting a restitution hearing April 4th at 11 o'clock. Ms. Henry's presence will be waived.
Thank you, Judge.
Okay. All right, the court has considered now the statements of all the parties. There's not much more this court can add. This is obviously one of the more horrific cases that this court has ever had before it. The court, however, greatly appreciates both memorandums from the parties, especially, frankly, I guess the defense memorandum that adds context to, doesn't explain anything, but adds context to perhaps what leads up to something like this. The court also agrees that the resolution in this matter is a just resolution, and that the state, in dropping the notice of death with the plea agreement, in the decision-making, came to a very just decision in doing so. As to counts 1, 2, and 3, then the court finds that probation is not appropriate. The court finds, based on the fact of the dropping of the notice of death, there's only one sentence that may be imposed on each count. It's therefore the judgment of the court as follows. As to count 1, imposition of sentence, defendant is sentenced to a term in the Department of Corrections for a term of natural life to begin today's date. I will give credit on count 1, which is 1,852 days of credit. As to count 2, it's ordered the defendant be imprisoned in the Arizona Department of Corrections for a term of natural life. That should be deferred, Monica. All right. With 0 days credit. As to count 3, defendant to be sentenced to the Arizona Department of Corrections for a term of natural life with 0 days credit. It is ordered that count 3 shall run consecutive to count 2, and count 2 shall run consecutive to count 1. The court notes first that the plea calls for consecutive sentences, and the court is following the plea agreement. Secondly, the court also finds that each victim deserves to be recognized as an individual victim, and consecutive counts are therefore warranted to consider the impact, obviously, on each victim from Ms. Henry's actions. Therefore, the consecutive sentences are warranted in this matter. The court will retain jurisdiction over restitution on count 1 for a period of 5 years, waives the defendant's appearance. Financials to be imposed on count 1, beginning today's date, a $20 time payment via $20 probation assessment, $13 criminal assessment, victim rights of $9 and $2. It is ordered dismissing counts and allegations in paragraph 3, with defendant to undergo DNA testing for law enforcement purposes. Ms. Henry, because you did plead guilty, you do have the right to petition the court for post-conviction relief and have a lawyer represent you. If you can't afford a lawyer, one will be appointed to you. If you can't afford copies of the necessary records and transcripts, they'll also be provided to you at no cost. If you want to petition for post-conviction relief, you'll file a notice within 90 days of today, or you lose the right to seek that relief. You understand that the conviction suspends your civil rights, including your right to vote, serve as a juror, hold public office, and firearm rights. Actually, let me back up. You're going to sign in a little bit for a copy of your post-conviction relief rights. You'll leave us a fingerprint, have the ability to apply to set aside any convictions as provided by law. Again, the convictions suspend any civil rights, including right to vote, serve as a juror, hold public office, and firearm rights. You may apply at some point to have civil rights restored. The granting of that will be at the discretion of the court. It will not apply the restoration of firearm rights if convicted of a dangerous or a serious offense. You may also be able to petition the court for an order sealing all records of your arrest, conviction, and sentence related to the offense. If I didn't already say so, it is further ordered that a copy of the order of confinement, together with all pre-sentence reports, probation violation reports, medical and psychological reports not sealed, are remitted to the Arizona Department of Corrections. It's order remanding the defendant to the custody of the Arizona Department of Corrections to begin her sentence today, with all other orders not specifically stated reduced to writing. Is there anything else from the state?
No, Judge.
Any else from the defense?
Yes, Judge. There's one other thing. Miss Henry, because she didn't have a prior criminal history, she voted in the last election, and as a result, she's been called for jury duty in March. So we would ask that the court maybe, if you could vacate that for her.
I don't know procedurally how I could do that. Let me follow up with the jury commissioner to make sure, though, that she's taken off any list.
Thank you, Judge.
Okay. All right, anything else?
No, Judge, that's
Okay,
it.
so I think we'll take Ms. Henry out, and then she will return sometime later to sign all our paperwork.
Thank you.
Okay, thank you. Is it all good to sign? Okay. Okay. Thank you. Probably turn off the FTR. Right.
Form is in order. If you would publish the verdict and pull the jury, please.
Yes, ma'am. State of Florida versus Jermaine Lavonda Bass. Case number 22 CF 011717A. Trial Division 3. Verdict form. We the jury find as follows as to count 1, murder in the first degree. The defendant is guilty of murder in the first degree, Jayla Bass, as charged. And during the commission of the offense, did the defendant personally carry, display, use, threaten, or attempt to use any weapon or firearm? Yes. Did the defendant actually possess a firearm? Yes. Did the defendant discharge the firearm? Yes. Did the discharge cause death of the victim? Yes. 12 of the 12 of us find the killing was premeditated murder. 12 of the 12 of us find the killing was premeditated murder and felony murder. We the jury find as follows as to count 2, aggravated child abuse. The defendant is guilty of aggravated child abuse as charged. We the jury find as follows as to count 3, aggravated child abuse. Jermaine J.J. Bass. The defendant is guilty of aggravated child abuse as charged. We the jury find as follows as to count 4, attempted murder in the first degree. Jermaine J.J. Bass. The defendant is guilty of attempted murder in the first degree. Jermaine J.J. Bass as charged. And during the commission of the offense, did the defendant personally carry, display, use, threaten, or attempt to use any weapon or firearm? Yes. Did the defendant actually possess a firearm? Yes. Did the defendant discharge the firearm? Yes. Did the discharge cause great bodily harm to the victim? Yes. So say we all, dated this 27th day of February 2025, juror number 1, foreperson of the jury. Juror number 1, are these your true and correct verdicts? Yeah. Juror number 2, are these your true and correct verdicts? Yeah. Juror number 3, are these your true and correct verdicts? Juror number 4, are these your true and correct verdicts? They are. Juror number 5, are these your true and correct verdicts? They are. Juror number 6, are these your true and correct verdicts? They are. Juror number 8, are these your true and correct verdicts? They are. Juror number 9, are these your true and correct verdicts? They are. Juror number 10, are these your true and correct verdicts? They are. Juror number 12, are these your true and correct verdicts? They are. Juror number 14, are these your true and correct verdicts? Yes. Thank you. I can't see.
You missed one.
I can't.
I was 12. You missed
You missed 11.
11, excuse me. Juror number 11, are these your true and correct verdicts?
Yes, they are.
Thank you.
And juror number 12, are these your true and correct verdicts? Yes?
Yes.
Okay, thank you.
Thank you.
All right, ladies and gentlemen, I know that you have spent a considerable amount of time and effort today deliberating on this case, and I cannot thank you enough for that, as well as your patience and with us and hard work all week. As you've now seen, it is why we need people like you who respond down with a jury service summons to handle the cases and the disputes that the parties cannot resolve among themselves. So you are essential and a true backbone to our system of justice, and I cannot tell you how much you are appreciated by me personally, as well as all of the judges here in Tampa, Hillsborough County. That much being said, all of my constant admonitions about not talking about the case are obviously lifted. You can do as much speaking about the case as you would like to, or discussion or investigation or whatever you'd like to know in addition to what you've heard during the course of this trial. I do hope if you share your trial experience with others, it does have a somewhat positive spin, so that when they get a jury service summons, they too will come down to the courthouse, as you all have this week, to serve the citizens of Hillsborough as you all have. I spent a considerable amount of time as a trial lawyer before I became a judge. I loved to talk to jurors after cases to see how the presentation went and what questions jurors had or didn't have, or just talk about deliberations in general. That option is open to you. Of course, you're not required to do that, but if you wanted to talk to any of the lawyers, or if you have any feedback for me, let the bailiffs know, and they'll tell you not only you have my contact information, you're welcome to get back in contact with me, or if you want to come back in and speak to any of the lawyers about their cases, you're welcome to do that as well. But officially, your jury service is concluded with the thanks of both parties and with the thanks of all of my colleagues, the judges here in Tampa, Florida. So thank you very much for your service. Maybe we will see you down here next time you get a jury service summons, but thank you for all of your efforts this week. Have a great rest of your week and weekend. All rise. All right, have a seat. Any reason not to proceed with sentencing at this time?
Well, Judge, yes, we'll be filing motions, and also there would need to be a score sheet for the other counts, so I would request sentencing be set off.
All right.
And I also need to discuss then very briefly as well with Mr. Bass about a PSI.
All right, sure.
That's fine, Judge. I had not prepared a score sheet. Obviously, I didn't know what the verdict would be or what if it could be lesser, so I just didn't have anything prepared. But and I know, Judge, in speaking with the family, I believe at least one of them would like to say something. So I know if we can just maybe have another date.
All right. Of caution in case this affects either side's sentencing request. This will be my last jury trial. I am retiring effective in a couple of weeks for another opportunity that I have to go into private practice that I'm going to take up. So I won't be the sentencing judge if you want to defer it.